Based on my experience, I'm here to tell you that the Delaware U.S. Attorney's Office and Department of Justice handling the Hunter Biden tax investigation was very different from any other case in my 14 years at the IRS.
A month ago, President Biden's son Hunter was given a deal on tax and gun charges that mean he'll probably avoid a prison sentence. And with every day that passes, it's getting harder to believe Attorney General Merrick Garland's insistence that there wasn't interference in the case.
At every stage, decisions were made that benefited the subject of this investigation.
The latest revelations come from Gary Shapley and Joseph Ziegler, experienced IRS agents who 2 months ago spoke behind closed doors to the House Ways and Means Committee.
Between 2014 and 2019, this brings the total amount of foreign income streams received to approximately $17 million, correct?
That is correct. The purpose of documenting the foreign sources is as a part of a normal international tax investigation, we have to figure out where the money's coming from. You have to follow the money trail.
Both IRS agents' appearance in front of the Republican-led House Oversight Committee was their first in the spotlight.
The assigned prosecutors, all 4 attorneys, agreed to recommend felony and misdemeanor charges for the 2017, 18, and 19 tax years.
During 6 hours of testimony, both men said the Justice Department interfered in their investigation. That included tipping off Hunter's legal team to a planned search and preventing questions related to Joe Biden.
The result was that only one witness spoke to investigators that day.
Concealing the contents of Hunter Biden's laptop.
Investigators were not allowed to follow up on WhatsApp messages from Hunter Biden's Apple iCloud backup, where he suggested he was sitting next to his father.
And preventing access to the FD 1023 document, in which an FBI informant alleged that Joe and Hunter each accepted a $5 million bribe from Ukrainian energy giant Burisma.
There's things that are contained on that document that could further corroborate other information that we might be having an issue corroborating because it could be regarding a foreign official.
Their complaint is that they weren't allowed to follow it. They have suspicions. They say that there were many leads that would have potentially have led to the president, but that time and again, both the prosecutors and at times the FBI stepped in and would not allow them to do that.
So far, neither the White House nor Hunter have commented on the allegations. The IRS inquiry began in 2018, but within a year it became part of a federal investigation into Mr. Biden's finances, headed up by David Weiss, the U.S. Attorney for Delaware. In April last year, Merrick Garland was questioned about the appointment.
How can the American people be confident that his administration is conducting a serious investigation?
Because we put the investigation in the hands of a Trump appointee from the previous administration, who's the United States Attorney for the District of Delaware. He is in charge of that investigation. There will not be interference of any political or improper kind.
In testimony, Mr. Shapley said that was not true.
The Justice Department allowed the president's political appointees to weigh in on whether to charge the president's son. After United States Attorney for D.C., Matthew Graves, appointed by President Biden, refused to bring charges in March 2022, I watched United States Attorney Weiss tell a room full of senior FBI and IRS senior leaders on October 7, 2022, that he was not the deciding person on whether charges were filed. That was my red line.
To this day, I do not have a reason why that occurred. From my perspective, this might not have been problematic had the investigation been handled in the ordinary course.
In a letter to House Judiciary Chairman Jim Jordan on June 6, Mr. Weiss writes, "I have been granted ultimate authority over this matter, including responsibility for deciding where, when, and whether to file charges."
While the impression has been conveyed by the U.S. Attorney in Delaware that he has similar powers to that of a special counsel in this case, free rein to do as needed, that was not the case. It appeared to me, based on what I experienced, that the U.S. Attorney in Delaware in our investigation was constantly hamstrung, limited, and marginalized by DOJ officials as well as other U.S. attorneys.
If he never requested or denied special authority from Attorney General Garland, as he told us on October 7, the American public deserves to hear why he allowed 2014 and 2015 D.C. charges to expire.
He stated that he agreed with us regarding the 2014 and 2015 tax year misdemeanor and felony charges, but that this could somehow affect the later year misdemeanor and felony charges that he conveyed were stronger.
No number of carefully worded denials or evolving half-truths can overshadow this stark fact.
If Mr. Garland and Mr. Weiss want to persuade the American public that they're telling the truth, perhaps it's time to follow in the footsteps of the two IRS agents and answer questions under oath.